Thursday, you know that we discussed the Trump administration's use of the Alien Enemies Act to deport migrants in the Supreme Court's Birthright hearing. We had a busy week.
It was busy.
Indeed. The phones just lit up like crazy. And, of course, we did our best. We don't have all the answers. We needed an expert to explain the nuances of all of these headlines. So we invited Ross Miller. He's a managing shareholder at Gonzalez Olivieri, LLC, immigration firm in Houston. He currently serves as treasurer for the State Bar of Texas Immigration and Nationality Section. And he has argued immigration cases before the 2nd, 5th, and 11th Circuits and has successfully represented clients before the United States Supreme Court. Ross, that's a pretty good resume. I'm glad you're here.
Well, thanks, Frank, and I appreciate the opportunity to be here to discuss some of these
what's
issues.
the biggest question you're getting right now?
So the biggest question that we're receiving right now is, how do we plan? What do we do to be ready in case there's some type of enforcement action that's taken against me, against my business? And I mean, the reality is it's a case-by-case situation. It's different for everybody. Everybody's situation is obviously different. But my recommendation, number one, is to try to not panic. Try to understand, this is still a nation of laws. We have due process. You have opportunities to apply for different forms of relief. But my recommendation isn't to wait until the very last moment, when you have an enforcement action being taken against you. There are different ways you can prepare. Get your file from immigration, for instance. That can take a few months. So, if you walk into an attorney's office and you say, my spouse has already been detained, what can you do? Well, it's a bit of a struggle for the attorney to get all of the information about what's happened in the case. If there's a deportation order, that makes the case very different. So preparing, knowing your options beforehand instead of waiting until the last possible minute, that's really the best advice that I can give right now with all of the fast changes that are happening.
If you have questions for us, give us a call right now at 713-440-8870. Just do a little setup for us to understand. When we talk about the Alien Enemies Act, your understanding of it and how you see it being interpreted today and what you think is valid and isn't.
Sure. So this is a particularly obnoxious statute from 1798 when Adams was president. This is the War of 1812. So basically, this is where it comes from. The idea here is if you are a member of a country, a hostile foreign power to the United States, if you have declared war on the United States or there's a risk of invasion into the United States, the U.S. government can use the Alien Enemies Act to detain, but also to remove or deport somebody from the United States. And that bypasses typical safeguards in terms of procedural due process, the right to a hearing, the right to ask an immigration judge for relief from removal. When the Alien Enemies Act is applied, those protections don't apply. And probably the most famous instance of this happening was during World War II. Members of the United States who, were German or Japanese nationals basically had their rights trampled. They had no due process. They were detained, removed from the United States. And so while federal courts have historically granted the executive, the president, pretty broad powers when it comes to immigration and national security, in recent years, the courts have been more reluctant to give unfettered power in these regards. And that's kind of what we're seeing under President Trump's use of the Alien Enemies Act. So courts in Texas, here in the Southern District, which is where Houston is, courts in California, Colorado, New York have all basically said there is no invasion to justify use of the Alien Enemies Act to detain and deport people of Venezuelan origins. But the administration has argued that the Tren de Aragua gang, which is centered in Venezuela, basically is making an invasion or an incursion into the United States, which renders the Alien Enemies Act applicable.
So that's where the whole case really holds, whether or not you can say this is an invasion and can support that idea from a hostile nation. If that isn't there, then you cannot use the Alien Immigration Act.
That's
Alien
correct.
Enemies Act.
Correct. There's no justification for the statute to kick into effect. And today,
so that's where the court cases are settling on proving that?
So that's part of it. The other part is, okay, if there is an incursion, if there is an invasion, what procedural due process is required under the Alien Enemies Act? So the Supreme Court, this case was recently in front of the justices. They didn't decide the merits of the case, but they said, there has to be some type of notice. You have to tell people that we are enforcing this act against you because we believe you are a member of the Tren de Aragua. And you have to give people who are subject to this act some type of opportunity to contest a finding that they are in fact
even if
subject.
it's the Alien Enemies Act, due process must be present.
Correct, and that's what the Supreme Court has recently decided. And so that kind of demonstrates a shift in thinking from, historical interpretation, which is there's simply unfettered access or unfettered privileges for the executive.
Now, Ross, I want to bring it back to Houston, right here in Houston, because we have a lot of people with different types of statuses. And I think that we've been talking in very broad strokes, either, they have papers or they don't have papers. And you said you're getting a lot of questions. And one of the questions that I have is, as an immigration attorney, people that may not have representation, what should they know? And when I can tell you from firsthand experience, I know one of our nanny who we absolutely love. She has a visa. She this morning came and she is freaked out, for lack of a better word.
Sure.
And she's worked for us for 3 years. She is one of the most outstanding people I know. She has a visa. It has expired. She has asked for her renewal. And what can I tell her to give her some relief? Because she is in a panic. And you said, don't panic.
Sure.
But that's very easy to say when you're like, oh my gosh.
Yeah, for sure. Easier said than done, and I completely understand that. Going to a lawyer is kind of like going to the doctors. Nobody wants to do it, but you have to if you're unwell or you have some type of issue or situation that needs to be addressed. So what I would say is before, someone like your nanny or somebody in a similar situation, before they panic, what they need to do is consider their options. Find out exactly where their case is. Oftentimes, if you are changing from one form of status to another, your status can be extended, right? Oftentimes, you can apply for a new form of relief. So many people who came in, for instance, under the paroles that the president has since reversed, people who had TPS, temporary protected status, or continue to have temporary protected status. Depending on the certain facts of their case, they may be eligible to apply for lawful permanent residence or some alternative form of status that can extend their period of authorized stay, employment eligibility. But it's important to not wait till the last possible second to do that.
Well, that's what I was going to ask you. Is I would imagine these timelines, it takes a while to get your paperwork together, to seek a lawyer. So what can people do in the meantime as they're waiting here? And can they just get picked up by ICE and sent home? I know we were talking about the due process.
But before you answer all those, to go back to Celeste's earlier question, though, the person we're talking about.
Yes, I paid taxes. I'm putting this out there, but the other people have employees that help them.
Do you move for an extension or a renewal before your visa expires, or do you have to wait till it expires to then request? Could people be planning ahead?
Mm-hmm.
Yeah, that's a great question. You do not have to wait, right? You can try to basically move to a different form of status if eligible for it. You can try to apply for an entirely new form of status, like lawful permanent residency. It's important, though, that you know the facts of your case and that you speak with a practitioner who is well-versed in immigration law. Many of our clients at the firm are from Central America, Mexico. In many of those countries, a notary is considered a legal professional. In the United States, a notario is not a legal professional.
A notary, yeah.
It's exactly right. And you have to be very careful about taking legal advice from somebody who has absolutely no legal training and, frankly, is operating a practice of law without legal authorization. You don't want to make these types of mistakes. We get clients who come in all the time and get very bad advice. Don't reapply for this particular benefit. You don't need to worry about that. Don't file this form. Well, those seemingly small mistakes in the immigration context carry very significant weight. The other thing is, you asked about, can somebody be picked up? Well, it depends on the facts of each individual case. So sometimes you'll have somebody who's lived in the United States for 20 years. They have no criminal record. They actually pay taxes, but they have a deportation order. They missed a hearing many, many years ago. And that person with an active final deportation order can be picked up and they can be removed. And there's very limited options for people to be able to help someone in that situation. But you could file a motion to eliminate the deportation order, to get it reopened. Due process, again, is still a thing. If you didn't get adequate notice of your hearing before you were ordered removed, that's a basis to reopen and rescind a deportation order. But you have to get those records. You can do that through a Freedom of Information Act request on behalf of the client, but that can take a few months to get those records. So it's something where you don't want to wait to be in a position and say, you know, my spouse was picked up yesterday. What can you do for me now? It's something where you should definitely move to plan in advance.
Well, aren't people a little afraid to put their head above the water?
Yeah, that's a great
Because
point.
I start to do all of this, and now they're going to know
And
where I
I'm
am and
giving
who
you
I
my
am.
information.
They're just going to come
I'm
pick me
giving
up
you
and
where
send
I
me
work.
Right.
And, yeah.
How do you navigate that? Or just go to a lawyer and let him do it?
That's a very, very important question. There are certain ways that you can request records, obviously, without sending a client's address to immigration authorities. However, oftentimes when you file a motion to reopen, you do need to provide the non-citizen's address to the government, right? So there are certainly situations where there is no other alternative but for providing that type of information to the government to comply with legal requirements. And that's why you need to speak with an attorney to be able to assess the risks, the possibilities for relief, rather than going to somebody like a notario who is going to give bad advice and skip over all of those details.
We are speaking with immigration lawyer Ross Miller. We are taking your calls, questions, and comments at 713-440-8870. As you talk about this, what I keep hearing is talk to a lawyer, talk to a lawyer. I believe a huge number of folks that are finding themselves in this situation probably don't have the resources to go for a lawyer. What advice do you have for them?
Yes, that's a great point. It's very unfortunate because in these instances, if I, would consult with a client who couldn't afford our legal services, we are a private firm. In those instances, I would say, there's an organization called Catholic Charities. You don't have to be Catholic to go. They can help people pro bono or low bono assistance. However, under this administration, many of the grants and funds for nonprofit immigration services have been drastically reduced. There is a bill pending before the Texas Senate, I believe, that's trying to eliminate any type of municipality or public funds from going into these types of services. So they're, Catholic Charities, groups like that still operate, but they are operating with a much more limited budget. And so unfortunately, in the immigration system, one of the big misconceptions is that you have a right to a lawyer and that the government will provide that lawyer for you, but that's not the case. You have the right to seek out legal services, but there is no right that the government is going to provide those for you. Even a child as young as 4 years old is not entitled to an immigration attorney in immigration proceedings.
When we talk about undocumented people, we kind of have this in our mind that somehow they swam across the river, jumped the wall, somehow got away with it, and now they're just trying to make a life for themselves in America with no documentation. How else would they have done it?
Well, I think the other point to that is that they're not trying to make a life for themselves. I think the point is that people feel like they're taking advantage of hospitals, of our systems, and of our things.
Oh, sometimes. I guess that accusation is
That
there.
is, I think, the big accusation.
I guess what is the reality of the undocumented in this country currently? Who are they, basically?
And where'd they come from?
So the vast majority of people who are undocumented in the United States, there are estimates that there are 12 million undocumented people. Most of them are of Mexican descent. And many of those people have been in the United States for 15, 20 years, even longer. Many of them have children who are citizens. You mentioned there's this widespread misconception about people using public resources. I have clients who are undocumented who come in and, they ask about public benefits for their children. And I explain to them, your children are citizens. They are entitled to this benefit. Take them to the hospital. You don't have to worry about that. And they're still apprehensive about it. They're still afraid, even though their children, again, are citizens and they're entitled to use those types of benefits. And Frank, to your question, many people who come to the United States come legally. They come on a visa. They come with some other type of permission. We have many Venezuelan, Cuban nationals who recently came in on a parole that the administration revoked the parole for. So not only is the administration targeting more undocumented people who are already in the country, but they're also putting more people into the undocumented category by revoking paroles and not giving them the opportunity to seek some type of lawful status.
And revoking visas.
Correct.
I mean, student visas have been revoked, and I guess HB1 visas have been revoked.
That's right.
And then, for some reason, Afrikaners all come in.
It definitely doesn't match the talk that the president has made about refugees, right?
Right.
And again, cutting resources for refugees who are trying to relocate to the United States, people who are victims of harm and persecution. This comes after, World War II, when the United States saw the liberation of concentration camps, and they said, wow, we recognize this was happening, our government knew this was happening, and we didn't do enough to protect people who were fleeing harm and persecution. That's where those laws come from today, and I mean, they're really under assault.
So much to talk about on this topic, but I don't want to run out of time and not talk about birthright citizenship since you brought that up. That too now is under attack.
Absolutely. Yeah. So, birthright citizenship, the Supreme Court recently had a hearing on the whole issue of birthright citizenship. This is something that, as I said, President Trump is moving to basically put more people into the undocumented category. Birthright citizenship, it's a guarantee since 1868, right? The 14th Amendment clearly states if you are born in the United States, you're subject to the jurisdiction thereof, and you are a citizen. Either you're born or you're a naturalized citizen. I'm a citizen of the United States simply because I was born here. But President Trump is saying, well, if your parents are undocumented or if they came on a visa, then you would not be a citizen under his executive order. And the whole idea here is this notion that, I hate the term, but anchor babies. People come to the United States for the deliberate idea or reason to have a U.S. citizen child. It's Willy Wonka's golden ticket. They're going to petition for me. I get status. That's not the way it works, though. That's a total misconception. If somebody comes to the United States illegally without permission, that person needs a waiver for unlawful presence. Only a parent or a spouse with status can do that waiver. So your child who becomes a citizen, they turn 21, they can petition for you. It doesn't mean anything. You can't use that petition to get any type of status.
Just help me with one thing that I may be wrong on. The Supreme Court hearing that was happening was not necessarily about birthright citizenship. It was about if a single judge blocks a presidential order, that somehow they have more power than the executive branch by being a single voice can block it. That's actually what the hearing was about, not the issues of birthright citizenship. Am I right on that?
You are exactly right. And I mean, it's open to interpretation. My belief here is that the Department of Justice under the administration basically didn't even brief the merits of the birthright citizenship issue, because every court that has heard this issue has said the executive order is blatantly unconstitutional. So instead, what the administration is saying is, and this is something that President Trump, but also other administrations have complained about quite frequently, Democratic and Republican, they're saying it's not right for a single district court, federal judge, to impose a universal injunction, an injunction that basically blocks a federal policy nationwide. That's the big issue, but realistically, when you have judges, I mean, you look at the Alien Enemies Act situation, you have multiple judges saying different things, although most judges have said, Alien Enemies Act, you can't deport people under this act. In the Southern District here in Texas, that's what we have. But in the Western District of Texas, Judge Haynes, who's a Trump appointee, said you can deport people under the Alien Enemies Act. However, you have to have certain safeguards, 21-day notice and an opportunity for the non-citizen to basically contest whether or not they're actually deportable under that act. And so you have this patchwork of different judicial decisions that are bubbling up until you reach the Supreme Court, which is the final arbiter of the law in the United States. And that's kind of what the issue is whether or not you would allow a universal injunction to be in place so that people aren't harmed during the pendency of litigation. And so there is one policy of immigration throughout the entire country during that time.
Wow. Ross Miller is a managing shareholder at Gonzalez Olivari, LLC immigration firm in Houston. Ross, thanks for joining us today.
It was a pleasure. Thanks for having me.
Thank you.